Hi, my dear friends and subscribers. HR Resonance channel welcomes you. So far, you were able to view various videos on different topics. Today, I am presenting you another interesting and relevant topic of the video on labor codes women provision. In the other words, what are all the provisions contained for the women employees? I hope this may be interesting and useful videos all in one shot. Let me start with the Code of Wages 2019, wherein the provision contains about the disqualification for bonus. If any employee dismissed from service for conviction of sexual harassment, then that is the he is disqualified for the bonus. So that is one of the provision. So therefore, the women laws are stringent on this. Another provision in Code of the Wages, one of the act amalgamated or included is ERA, that is Equal Remuneration Act, wherein it states prohibition of discrimination on the ground of gender. It states no discrimination on the ground of gender relating to the wages in respect to the same work and same similar nature of the work done by any employee, and reduce the wages and discriminate on the ground of sex while recruitment also. So this is the provision for the women employees, therefore, so that equal treatment one can see in that. Then coming to the Social Security Code, in that chapter 6 specifically mentions about Maternity Benefit Act. It was one of the act amalgamated in that. So Maternity Benefit Act of section 59, it provides the provision for employment of or work by women prohibited during certain periods, like it means a woman when she is carrying certain works are prohibited, that is right of payment of maternity benefit subject to the 80 days working in the 12 months immediately preceding to the date of her expected delivery. In other words, the qualifying period for the benefit of maternity benefit is 80 days. Then when a woman dies due to in this period, then maternity benefit shall be payable only for the days up to and including the day of her death. So that is one of the important provision one must be aware. Supposing the woman dies and leave the child behind her, then employer shall be liable for the maternity benefit for the entire period. But if the child also dies, then for the days up to and including the date of the death of the child. Child includes stillborn child also, which one should be noted. Further, commissioning mother shall be also during the maternity benefit for the period of 12 weeks from the date of the child handed over to or adopted or by the commissioning mother. In other words, commissioning mother or adopting mother, she is also eligible for 12 weeks of the leave under the maternity provision. So, which is a beneficial to the women employees. They should note, and depending on the occasion, they are entitled. Further, employer and employee may mutually agree for work from home after the maternity period or during that period suitably. Section 64 of the Act and further mentions payment of medical bonus also. It is entitled to receive from her employer a medical bonus of up to rupees 3,500 currently. If no pre and postnatal care is provided for by the employer free of charge. This is one more benefit available for the female employees. In certain cases, there may be unfortunate miscarriages will be there. In such case of miscarriage or medical termination of pregnancy, a woman shall produce a proof and entitled to a leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage. So this provision also the employee should note. Further, in case of tubectomy operations, a woman shall, on production of proof, entitled with leave with wages at the rate of maternity benefit for a period of 2 weeks immediately following the day of her tubectomy operation. So this is good facility for the family planning, etc. Then women suffering from illness, many times arising out of pregnancy, delivery, premature birth of a child, miscarriage or medical termination of pregnancy on production of proof, entitled leave with wages at the rate of maximum 1 month. This is in addition to her maternity benefit. So these are all really very good provisions for the women employees. Further, after the child, there is a nursing break. Every woman delivered a child who returns to her duty after such delivery shall, in addition to the interval for rest, allowed to be with a baby and allowed in her daily work two breaks until the child attains the age of 15 months. So this is for the breastfeeding, which is most essential and required for any mother and child. Great, Matrudevo Bhava, that is what we say. Further, crèche facilities also provided. Where 50 employees are employed in any organization, it is a paramount duty of the employer to provide the facility of crèche by the employer and shall allow 4 visits a day to this by a woman employee, including that of her interval for the rest. Of course, there is a combined crèche facilities also there, that I am not narrating now. Then dismissal, where a woman employee absents herself in this, shall be unlawful for employer to discharge or dismiss her during this period or give notice. In other words, this period should not have a disadvantage for the woman. This is what all employers should know and follow in the interest of the law and in the interest of the need. Under section 70, during this period, she shall not work for remuneration. In such case, forfeiture of medical benefit will also be affected. This also the women should note. Don't think all are for employees for only. This is also the responsibility of the women employee who is under Maternity Benefit Act. Further, in the Social Security Code, under the Building and Other Construction Workers Act, under this, if she registers as a beneficiary, she is entitled to various benefits as laid down under the Act and the Code by respective states from the Construction Welfare Board. Various benefits are there. For that, my dear friends, you have a look at my other video, detailed video on BOC benefits for the worker. Further, the code in Industrial Relations Code, IR Code, one of the important provision is in bipartite bodies, grievance redressal committee, wherein there shall be an adequate representation of women workers, and such representation shall not be less than the proportion of women workers to the total workers employed in the industrial establishment. This is the provision relating to the Industrial Relations Code. Well, friends, these are the provisions under Code of Wages, Code on Wage, then Social Security Code and IR Code. Next important and the last code, which is very important, widely covered, where in factory, mine, plantation, they are all covered. Here we see a provision on hazardous factories, including more hazardous industries, wherein the provisions are more stringent and some of the provisions are extended for women employees. Ultimately, what? Adequate safety of employment of women in dangerous operations. Section 69 of the Occupational Safety Code mentions employment of women during the night or before 6 a.m. to 7 p.m. in any industry, that is all in hazardous industry. Even if at all employer engages them on overtime, the consent of women employees shall be taken. Further, no woman shall be employed against the maternity benefit provisions laid down under the Social Security Code. That is what it states in Occupational Safety Code, which is really good also. Then adequate transport facilities free of cost shall be provided for pickup and drop of such employees at her residence. This is really good and beneficial and carries the safety. Workplace, that is including passage towards conveniences or facilities concerning the toilet, washroom, drinking water, entry and exit of women employees should be well lit. Of course, this is one of the important safety points. The toilets, washroom and drinking facilities should be near the workplace where such women are employed. And also, the employer has to provide safe, secure and healthy working conditions such that no women employee is disadvantaged in connection with the employment. So, employer has to provide a dignity and safety consciousness in the mind of all the women employees. The provisions of the sexual harassment of women at workplace provisions, the act which is supreme and which is applicable to the establishment, shall be complied with in respect of all the provisions ensure safety and security of all women workers employed. It is insisted there also, along with all other provisions. Adequate safety of employment of women in dangerous operations are also specially mentioned. The pregnant woman shall be required or allowed to work in a factory involved in dangerous operations where she is likely to be exposed to the hazardous substances which are carcinogenic for herself and teratogenic for her fetus. There, where special provisions have been ensured. And all the measures as mentioned in the provisions related to the hazardous processes and dangerous operations shall be complied with without any hesitation and very strictly. Provisions are very stringent. Women employees shall be well trained on their job and shall be rendered knowledge about the hazardous properties of the substances being handled, stored, manufactured, hazards present at their workplace, and measures to overcome with that. With all proper SOPs and MSDS, they should be educated and aware that message has to be drilled and they should be confident in that. This will help in the long run and compliance of safety provisions. Women employed shall be provided with all the necessary personal protective appliances at the workplace and they are deployed. That is also very important. Only providing is not important. The employer has to ensure their proper usage with a due training. Women shall be trained and made aware about the means of escape in the events of the fire, leakage, spillage of hazardous substances. Well, friends, these are all the provisions relating to the women employment. as far as the hazardous industries are all concerned. Of course, in current days, in most of the industries, much discrimination is not done, but even then, government has taken enough care and provided various stringent measures and the provisions in respect of women employees to work freely with dignity, with all equality at the workplace, and it should not be discrimination, or it should not be discrimination for her any time or disadvantage. Well, my dear friends, I hope this video particularly useful to all women employees and for all HR, admin, legal, MBA students fraternity to know the provisions that are involved in the labor codes of India. For more and more details, wait and look for my other videos. Well, my dear friends, I hope this video, if you have found useful and beneficial, don't forget to subscribe and share to all your needy required. Let the message reach. Then my job is worth. Thank you very much, my dear friends, for having you and observed my video.